We have a number of topics to try and cover this afternoon. One of the areas that I think remains a challenge, it's like income tax. There's nothing new in our fact situation that gives rise to any employment and labor law issues that weren't prevalent before. But one of the things in high tech, and someone mentioned it this morning, or in a lot of information technology businesses, is in large measure what we're acquiring is a labor force, or we're buying people to the extent you can buy people. And so the labor and HR and employment law issues have continued to be important and will be important in these kinds of businesses. We have speaking to us this afternoon Bill Phelps and John Barrack, both with the firm of Matthews, Dinsdale, Clark. Matthews Dinsdale represents management exclusively in labor and employment-related matters because there don't seem to be very many unions buying businesses. It's the management firms who also consult and advise their clients on the labor and employment aspects of acquiring businesses. Bill did part of his education at the University of Michigan and then at the University of Toronto. He's practiced even longer than I have. Was made a QC in 1985. We're actually quite lucky to have Bill here with us because when the weather gets nice, he tends to take off to his cottage up in Lake Couchiching, where he spends time cottaging and sailing. Now, he told me earlier that he has to leave shortly because he has a dispute and he has to go represent one of his clients. I'm not so sure. John told me he actually has a tea time for 2:30, so I'm not sure which it is, but we're delighted to have him here, and we're delighted to have John as well. Thank you.
I wish it were a tea time. It would be more pleasant than what I have to deal with this afternoon. I looked at the title, and it said from widgets to websites, and I felt really competent to deal with this. I think I know more about widgets than I do about websites. Look at the fact situation in this case, and what we have is a unionized company in Brantford, about 120 employees, and then that's going to be acquired by our client, who is non-union. We're not really quite sure from the facts where our client is. But one of the things we want to look at is the question of what happens to the unionized employees. Does the collective agreement attach to the business the same as a mortgage attaches to a property when you buy the property? What happens if you integrate the union with the non-union business? Those are the kinds of questions that come up in my section of the paper. And then John will deal with issues like the employment standards issues and the restraint of competition issues that you can look at when you're selling or buying a business. Often the labor relations implications are forgotten in terms of, in comparison with tax and with straight operational and with financing considerations. We've got a fairly lengthy paper under tab 10, and we don't plan to read from it, but just to introduce you to what is there. First of all, we look at the sale of business provisions, and this is on the page that's numbered. Actually, it's not even numbered. It's the third page under the tab. And the concept here is raised under Section 69 of the Ontario Labour Relations Act. If you turn to page 2, you'll see that the phrase business includes a part as well as the whole of the business, and that sell includes lease, transfer, or any other manner of disposition. It's even been held to apply to a gift. So you can't take the sale of a business language too literally. Those sections are long, they're complex. I don't propose to take you through them, but just to understand what some of the issues are which arise under this section. Basically, the concept is that in the fact situation of our case, if we buy this unionized business, we get the union, we get the collective agreement, we get any outstanding grievances, we get any dismissal claims, we get unfair labor practices, we get all of those things as part of the package. That's what Section 69 says. It's there to preserve the bargaining rights and the collective agreements of the union. And certainly the way that the facts are structured in our case, there's no doubt that Section 69 will apply and the purchaser will be bound by the collective agreement. Now, the creative lawyer is often asked by his client, well, is there some other way that we can do this so I can avoid the union? And that's why we've got a lengthy series of issues that we discuss. On page 4, we talk about the definition of a sale of a business, and that goes on. At the top of page 5 is one of the key things to note. While the Labor Board recognizes that corporate lawyers will draw an important distinction, as tax lawyers will, between the sale of assets and the sale of a business, the fact that you structure this as an asset sale does not prevent the union from flowing through. The purchaser acquires all of the bargaining rights or is bound by all the bargaining rights, as I said before, a notice to bargain if the company is in the middle of negotiations, the unfair labor practices, the grievances, and so on. If we go on to the middle of page 6, just about in the middle of the page, we point out that the Labor Board, which administers the Ontario Labour Relations Act, has developed certain indicia or criteria about when a sale has taken place. And in the quote that follows near the bottom of page 6, you'll see that it's not a question of whether the logo was transferred or the company name or the goodwill or the accounts receivable. There are lots of cases in which the board says the goodwill was transferred and therefore we find that there was a sale of a business, let's say in an asset sale transaction. The goodwill was part of the assets. But then the board turns around and in the cases where the purchaser did not acquire the goodwill, the board says, oh yeah, well, you don't have to buy the goodwill to have a sale of a business. So that is not determinative. What are the key determinators? Probably without pointing to any particular section in the paper, if you just want to take a note, if the majority or a substantial number of the employees go to the purchaser, if the purchaser continues on the same type of business endeavor, those two are probably the key indicia. There are a lot of other criteria that are discussed as we move through page 7. We talk about what constitutes a business or a portion of the business. Let's say that Cyber Store was just selling half of its product line and leasing half of its premises in Brantford. Does the collective agreement go with that? That's the issue that this section speaks to. If we go on to page 9, the first quote under the subheading says that the most appropriate test to be applied is whether the nature of the work performed is the same as the nature performed before. In other words, it gives kind of a pith and substance or a functionality test. And that is the same business going on? Question often arises, what about a hiatus of the operations? And some older cases said, well, if the business had been out of business, let's say there'd been a bankruptcy, for example, or a poor market condition in which the business, let's say, had just gone dormant, and then a purchaser comes along a few months later and picks up the assets, is that still the same business? And the early cases said, no, it wasn't going concern. The subsequent cases have said a hiatus is irrelevant. There may even be a period of dormancy. And we'll find the flow of a business even through that dormancy. Page 11, we talk about the issue of goodwill, and I've already spoken to that one briefly. Page 12, if we're talking about transfer of customer lists, that's going to be another key indicia. as is the transfer of the key persons. Who are the people that make this cyber store go? Are the operations people who maintain the essential quality in a high-tech operation, are they going through? Are the design people going through? Are the marketing people going through to the purchaser? That's one of the key indicia. There are some cases going to the bottom of page 13 and the top of page 14. If we have a dispersal of the assets, you're selling the vehicles back to a leasing company, the real estate is going to revert to the landlord. Some of the production equipment is going to a purchaser, and other production equipment is going to another purchaser, and inventory is being dispersed. Then we probably don't have the sale of an asset of a business as a going concern. It's going to be a question, as we say in the middle of page 14, what is the core assets? What are the things that really make this business go? Then we get into the question of, does the sale of a business through, or let's say it this way, the transfer of a business through a bankruptcy or an insolvency, that may extinguish the prior debts of the vendor company. Does it extinguish the union bargaining rights? And the quick answer is no. There's a multitude of cases which establish that. There's even cases, if you happen to be advising a receiver, that say that the receiver himself, in his own capacity as receiver, it can be deemed to be a successor employer bound by the union's bargaining rights. Many of the receivers are able to negotiate, let's call it a kind of standstill arrangement with the union, in which the receiver does not become bound by the collective agreement, but is able, makes an undertaking to live according to the terms of the collective agreement as if they were bound by it. So you can't extinguish the collective agreement or the union's bargaining rights by doing a bankruptcy and thinking that you're washing out that obligation along with the indebtedness. Moving to page 16, you get the problem of what happens in our case if, as our fact situation kind of hints at, what happens if we intermingle the operations and the employees of our purchaser client with the unionized employees of the vendor, Cyberstore? What have we got then? Does that mean that all of the employees become unionized? What happens? Well, we've got three basically different situations. As we say on page 17, under heading A, well, let's talk about B first. Subheading B in the middle of page 17, because this is our situation. We've got a unionized vendor and a non-union purchaser. Then it's going to depend on where this business actually carries on. If our client buys the business with the intention of continuing it in Brantford, let's say it's just going to be a discrete operation, and let's say that our client's headquarters are, for example, in London or in Toronto or in Peterborough, and they're just acquiring this, and they're going to keep them as functionally separate operations, then we, the purchaser, will be bound by the collective agreement in the Brantford plant the same as the vendor was. But what happens, let's say, if we happen to be in Brantford or St. Catharines or Hamilton, and we decide that we're going to integrate the two businesses, and maybe we're going to move our previously non-unionized workforce into the Brantford plant where there was lots of space. Well, the law, the cases make it pretty clear that we are thus becoming bound by the union's agreement and the bargaining rights for all of our previously non-union employees who are being moved onto the site. Now, it may make sense, and maybe the collective agreement is acceptable, and maybe the economies from dovetailing the two workforces and getting rid of one set of overheads make it worthwhile. What happens alternatively if the company decides, well, we, the purchaser, are the bigger, say more modern, better equipped, better management information systems company, and we've got extra space and they're bursting at the seams in Brantford, and we're going to move that business from Brantford to where our purchaser's location is. If that's in Brantford, we've got a real pickle. And the case law goes off in several different directions in that circumstance. And it's one that you want to look at really carefully. To take the other extreme, let's say our operation is in Barrie, and we're going to consolidate all of those operations into Barrie. Then the first thing we've got to look at is whether the scope of the collective agreement and union bargaining rights are restricted to just Brantford, or whether they apply to the whole of Ontario. Assuming that they are restricted to just Brantford, then the union agreement does not follow when that operation is moved to Barrie. It does, however, raise another question, and that is, did we commit an unfair labor practice by closing the Brantford operation? Were we motivated by a desire to get rid of the union and to terminate people who were union members? And there you get into the question of whether an anti-union motive was any portion of the reason why Brantford was closed and the business was moved. And that becomes a strong evidentiary issue. So we've got to follow each of these issues through, and I think our message for you today is to be aware that there are potential arguments that the union can make, and if we're going to continue the same business in the same place with the same people, then the union's bargaining rights are going to apply. As you can see in situations A and C on 17 and 18, different results accrue if the fact situation were different. That leads us to the bottom of page 18 and a slightly different concept, and that is the concept of the related or associated employer. And this doesn't arise directly out of our fact situation in this case, but I just want to introduce you to this concept because it's often the union will hit you high with the successor employer obligation under Section 69 and with the associated employer application under Section 1, subsection 4 of the Labor Relations Act. Received one of those yesterday, and if they can't get you this way, they're going to get you that way. And what this 1.4 relates to is let's say, we'll vary the facts. So let's say that CyberStore was finding that it couldn't produce economically. It had a lot of problems with the union, and they decided, we want to get out of this union, and we're going to open a new non-union company. And let's, for argument's sake, it was within Brantford. But instead of being CyberStore Limited, it was 1, 2, 3, 4, 5, 6, 7 Ontario Limited. And the question then is that second company bound by the bargaining rights and the collective agreement? The answer is probably yes. This is one place in law where the tribunal is given the authority to pierce the corporate veil, look at the realities behind, and to affix the union onto the second non-union company. And on pages 19 and 20, we've talked about some of the factors that the Labor Board will look at. I've already referred to the issue of unfair labor practices. As I suggested, if the company were to close, the acquirer were to close the business in Brantford and move it to Barrie, was that motivated by an anti-union consideration? And that is discussed under the heading of unfair labor practices on page 21. Now, just in a deliberate attempt to cause as much confusion as I can, I'm going to skip the section that starts on page 22 dealing with Employment Standards Act considerations, because John Barrack is going to deal with that in a few moments. And we're going to go over to page 27. While you're flipping over, I I was going to prepare something last night, and then I got home and I had to deal with a plumbing problem, and that reminded me of the story about the plumber who came, the lawyer who came home late at night and found the water cascading down the steps. Called his friend the plumber and said, "Come fix my problem," and the plumber did. 20 minutes work. He gave the lawyer a bill for $85, and the lawyer says, $85 for 20 minutes work? I'm a lawyer and I can't charge like that. Plumber said, "Neither could I when I was a lawyer." So next time your clients are complaining about your fees, you can try that one on. We have on page 27 a checklist of labor and employment law considerations for you to run through. When you're acting for the vendor, this is at the top of page 27, some of these other things are dealt with later on, but one of the primary considerations, and I'm acting for a vendor right now, and we're in the midst of collective bargaining, and the company is going to sell, and the question is, do we have to disclose to the union our intention to sell? Well, as this transaction is developing, it's going to be selling the business, it's going to be selling the shares of the business, so we're not obligated to disclose that. But if we were going to, let's say, sell assets and there was going to be a dispersal and the termination of a number of employees, we'd have an obligation to disclose that at the bargaining table. In addition, as John will mention, we have a number of concerns about fairness and notice and severance to employees who might be terminated if you are acting for the vendor. But we're not acting for the vendor in this case. On page 28, we look at the checklist when we're advising the purchaser. And the purchaser's considerations are going to include what is the scope of the recognition clause in the collective agreement. It's usually in the first paragraph or two of the collective agreement. Are the union's rights limited to just Brantford, or are they unlimited, in which case they'll probably be deemed to apply to the whole of the province of Ontario? Are there outstanding grievances and arbitrations? So one of my clients took over a company understanding, having accepted before I got involved just a verbal assurance that there were no problems, and then found out that there were 43 days of arbitration scheduled in the next 8 months. And in fact, there was a terrible labor management situation in the business that they were acquiring. Are there any special provisions in the CyberStore collective agreement that triggers any liabilities to employees, any severance payments, for example, just because the business has been sold? You want to check that out. You want to get a copy of the seniority list so you know what kind of accumulated service you're inheriting and will be liable for if you are subsequently to terminate any of those employees. You want to take a look at the hours of work and the overtime provisions of the collective agreement and see whether there are any restrictions on your operations. One of my clients just invested $100 million in upgrading their plant. And then they went to the CAW and said, "Will you please give us permission to operate this 7 days a week?" Well, fat bloody chance. So they're hamstrung now because they've got this huge investment and they can only operate it on 2 shifts a day, 5 days a week. You want to take a look at what wage increases have been promised. You want to take a look at the benefit plans, find out what obligations have been undertaken, what is the pension funding. Is there a huge past service pension obligation that hasn't been properly funded? Is the company about to go into collective bargaining? Are you going to take over? Is our client going to depend on a good cash flow from CyberStore to finance this purchase, and then find out that perhaps in June that they've got to sit down at the bargaining table and there's every possibility of a strike? And that could interrupt that cash flow and could interrupt customer relations. And then there's a list of things on page 30 that you would be wise to get from the vendor. That's my section of the paper. John's going to pick it up back with the employment standards section, and then he'll come back to page 31. As I say, I apologize for having to leave, but we've got these goons that think that they can interrupt commerce, and we don't have police that are helping us, so I've got to try and deal with that. Thank you very much.
So Bill has just taken us through the Labor Relations Act provisions. The other piece of legislation which is very important that you need to consider is the Employment Standards Act. And the Employment Standards Act applies to both unionized and non-unionized employees. So in this scenario, we're dealing with a union, non-union type situation, but the Employment Standards Act considerations apply in all cases. Just generally, most of you are probably familiar with the Employment Standards Act. It provides minimum standards with respect to terms and conditions of employment. It also deals with the minimum standards with respect to termination from employment. And that's really the key area, sections 57 and 58 of the Act, which are triggered in sale type situations. Now, unionized employees, more often or not, have the terms and conditions of employment covered in their collective agreement. So usually the Employment Standards Act considerations aren't as prevalent in a situation where a collective agreement contemplates dealing with, for example, severance and termination. And as Bill has just explained, there's usually a degree of security of tenure from old code and new code. Before we sort of go any further, I'd like to give you a little bit of an overview with respect to the termination and severance provisions, because quite often people throw around the words notice and severance without sort of understanding what that means. Section 57 of the Act deals with the notice provisions, and notice is notice of termination. And an employer is required to provide, and a vendor is required to provide, if the purchaser is not going to pick up its employees, notice of termination or pay in lieu of notice. And without going into great detail, it's usually in the amount of 1 week per year of service to a maximum of 8 years. Parallel to that, though, there are the severance provisions. And the word severance is used in a common law context and an employment law or an employment standards context. Under the Employment Standards Act, if you are letting people go, or they're not going with the purchaser, the vendor is obligated to pay out severance. And that is in the amount of 1 week per year of service to a maximum of 26 weeks. It's only open to employees who've been employed for at least 5 years. And if your payroll, the vendor's payroll, is in excess of $2.5 million. Over and above that, for non-union employees, there are common law obligations. As in any other wrongful dismissal action, if a vendor sells his company and the purchaser doesn't pick up the employees, the vendor's employees can sue for wrongful dismissal. So there is an additional potential obligation which you need to be aware of. I recently advised on a transaction where some corporate advice was given that unionized employees of a vendor would be entitled to common law notice. And that's just not true, and I want to clarify that. If the employees are covered by a collective agreement, there is no common law obligation. So turn to page 22 of the paper. You'll see that I just very generally want to go through the employment standards considerations with you. The general rule, unlike under the Labor Relations Act, is that a purchaser is not required to take on the employees of the vendor. But and if that's the case, then the vendor is in most cases, with one exception I'll refer you to in a moment, on the hook for any of the notice or severance obligations. But if the purchaser takes on the employees of the vendor, then the incoming employee's service is continued as if the employee worked with the purchaser for all of that period he or she was with the vendor. So if Billy is employed with the vendor company for 10 years, he then moves through and stays with the purchaser company for another 3 and then is terminated, the obligations are with respect to Billy's service being 13 years of service. Now, you'll see on page 22 of the paper, you'll see sub B, there's employment in the service sector. This is the building services, security services, cleaning, cooking. The Employment Standards Act makes an exception here. And quite simply, that exception states that if the incoming purchaser or if the service provider who has the contract for services, let me back it up. If you have a security company And security company A loses the contract, and security company B is awarded the contract to provide security services in your office tower, for example. Under the Normal Employment Standards Act provisions, security company B is not required to take on any of those people. But recognizing the reality of the business, that these really aren't sales per se, the legislation says if the purchaser or the new company providing the service, security service, building cleaning service, or dietary service in that building, if they don't take on the employees of the old company, the old security company, then the new company is responsible for paying out employment standards, notice, and severance obligations. And that's very, very often overlooked. And if any of you act for service providers, building service cleaners, security companies, and the like, food catering companies, that's something you really need to be aware of. It's 13.1 of the Employment Standards Act. It's a neat little provision which has caught some people who have tendered on security contracts and not been aware that they're stepping into these employment obligations. Employers in this area aren't required to take on the employees, but if they don't, they've got to pay them out. So again, that's covered in more detail in the paper. Moving across to point C and the subsets there, I've noted the general rule at little I number 1 that if the purchaser takes the employees of the vendor, then service flows through. Now, there are some circumstances where service will not flow through, and they're not always logically intuitive. And we need to be a little bit aware of some of the fine points there. If you skip ahead to point 3 on page 24, if there is a gap in employment between the time when the vendor's employees cease to be employees and the purchaser engages that same person, there may or may not be a continuity of service for the purposes of the Employment Standards Act. In short, if the gap is less than 13 weeks, in other words, if someone stops working for the old co and there's less than a 13-week break before he or she starts working for the new co, then there's a flow-through of service. If the gap is greater than 13 weeks, then there is no flow-through in service. That is for the purposes of the notice provisions and all of the other provisions of the Act, including pregnancy, parental, vacation, holiday pay, that kind of thing. But you'll notice under little I number 4 on page 24, there's a little difference there for severance. Severance payments need only be made by the purchaser if the gap is less than 1 week. So if there's a gap of 1 week or greater between when the employees of the vendor cease working for the vendor and start working for the purchaser is let off the hook with respect to the severance obligations. The neat little point to note again on page 26 is what happens if the vendor pays out severance to its outgoing employees before the purchaser picks them up. Section 58 sub 9 of the Act allows for a credit, so there's no double dipping. You can't get paid twice. Service may flow through, but an employee who is a 10-year employee with the old co, who gets paid 10 weeks of severance, can't pick up, after he's worked 3 years with NewCo, 13 weeks of severance. He is still a 13-year employee with NewCo, but his severance entitlement is really only 3 weeks. So those are the general Employment Standards Act provisions. I would skip you ahead now. Just a note very briefly on page 39. That's the numbering at the top of the page. There are a number of sample agreement clauses there. We've incorporated these clauses into the draft agreement of purchase and sale, which you have at tab 1. And I would just sort of take you to that document now and bring up just a very few of these items to your attention. The first of these is Article 1.3 with respect to employment records. We often see, again, as Bill mentioned at the outset, that the employment law considerations are abandoned or orphaned in a lot of these transactions, and often the purchaser doesn't get good information. And you really want to have very full information. In particular, at 1.3 sub D, around the issues, for example, of length of service, you want to know where there are breaks in those employees' service, because your long-term liabilities as purchaser is going to be very much dependent upon how long that person worked for a continuous period. Skipping ahead to the conditions of closing, you'll see there's reference at, I believe it's Article 4.1 sub 7 and 9, which deal with non-competition agreements and employment consulting agreements respectively. I'll deal with that at the very end because those are something which can cause a great deal of difficulty. Skipping ahead to 5.1 sub 8. Again, you really want to get the details in sub A of both benefit plans and employment contracts. Benefit plans can be outrageous. You don't know what you're buying. It can be a huge liability. The same thing with employment contracts. Be very, very careful. Often what happens is that the vendor knows he's going to be selling the business, so he signs everyone up to very generous employment contracts with very generous severance provisions, and you're stuck with it as the purchaser. So you want to know your liabilities there. Skipping ahead to sub 13, you'll see there are, at sub 5.1 sub 13, an article dealing with labor matters. Going back to Bill's earlier point, you want to know more than just, is there a collective agreement in place and who's covered? You want to know a lot of the soft information, such as, has there been organizing activity? You know, are there grievances looming out there that haven't formally been filed? Because those are huge liabilities you can be walking into. And if you get some of that soft information and require the vendor to provide you with that soft information, you're going to be in a far better position to make an educated decision in terms of either adjusting your price or whether or not your client wants the company. So I'd skip ahead at this point then to just to close on dealing with the Schedule B and C of the Agreement of Purchase and Sale, and those are the non-competition and consulting clauses. One of the areas we get a lot of questions around and cause a lot of grief are the scope of these non-competition and confidentiality agreements. And by scope, I mean both geographic scope as well as chronological scope. In this fact pattern that we're dealing with, I think the outgoing majority shareholder was interested in having an interest in the business as a consultant, and the purchaser wanted no part of it. If your non-competition agreement is with the shareholders, the people who are actually receiving the benefit of the contract, it's very easy to draw a restrictive covenant which is very broad in scope. And what we've proposed here is 60 months in North America wide. With technology, you may want to make it worldwide. The problem is, practically speaking, enforcement. With respect to your consulting agreement, the law in this area has grown up around employment law, and the courts will not allow you to draft an employment or consulting agreement that, at the end of which, precludes the person who is subject to the agreement from earning a livelihood. So that the scope there, you'll see we've drafted it as being Ontario-wide and for 24 months. Now, the one distinction we really want to bring to your attention, if the person entering the consulting agreement is also the vendor rather than a key employee, we would suggest elevating the scope to the same as the non-competition agreement, which you see in Schedule B. In other words, if the person who is the consultant is also receiving the lion's share of the consideration from the sale, the courts will allow you to construe a much broader geographic and chronological restrictive covenant. So that should be it, and if there are any questions, I'd be glad to take them. Okay, thanks.
Thanks, John. The next topic we want to talk about is representations and warranties. I think for lots of us, the representations and warranties are the part of the agreement that we think we know the best. It's in an agreement for purchase and sale, it's kind of the heart of the agreement. And as lawyers, the time we spend the most part on, because that's the part we tend to negotiate. And you're sitting in a room, often with your client, you've discussed those sections a fair amount. and you spend a fair amount of time on it, so we think we feel pretty comfortable with them. But this is a business that's a little bit new, a little bit different. It's one that I haven't spent a lot of time on. So we want to have a new look at these representations and warranties. We want to consider both the representations and warranties that we'd have in any standard business, and we want to look particularly at the ones that are applicable to this business, to an information-based business rather than a manufacturing-based business. And we have two people joining us this afternoon to speak to this topic. Fraser Mann, who we met this morning, is going to come back and tie in some of the things he talked about this morning into the kind of representations and warranties that we'd try and negotiate in an agreement of purchase and sale. And Hugh Laurence is also going to join us this afternoon. Hugh is on the planning committee for this program and was the author, along with Curtis Cusinato, of the fact situation, which I think all of us found quite interesting and has worked well for this seminar. I've known Hugh off and on for many years, and he's been, again, he was at the front of the cycle of being interested in computers and computer law. I remember many years ago working together with him in those areas. He's continued that interest. He's now manager of firm precedents at Davies, Ward & Beck, where he's involved not only in keeping their precedents up to date, but bringing technology and computers into that firm and helping lawyers like us become more efficient in how we use that technology in our practice and how we deliver value to our clients. I know, besides being active in the practice of law, I know at least one part of Hugh's personal life. I was at a concert not too long ago that was raising money for a charitable function. It was victims of landmines, and Hugh was singing in that concert. I have a CD at home. He's part of a choral group, and so I know he's active in other things besides the law. I think Hugh's going to start off, and Fraser's going to continue later. Thanks.
Well, what do you want to know? Because that's what reps and warranties are all about. What do you want to know? The vendor of the corporation is going to give you certain information. As a purchaser also gives some reps and warranties back to the vendor, but the key reps and warranties in a purchase and sale transaction come from the vendor. And the purchaser wants to know certain things about the business. In an asset purchase transaction, reps and warranties are fairly straightforward. The vendor is the corporation, and the vendor is in a position to give the reps and warranties. And since the purchaser is usually paying something to the vendor, we assume that the vendor probably has the wherewithal to back up the reps and warranties. I'll leave that particular discussion to Greg a little later on the whole problem of remedies and indemnities. In a share purchase agreement, though, you have to think for a moment about who is going to give the reps and warranties, because you need to know two things: who knows and who's going to back it up. Doesn't make much sense in a share purchase agreement to have the corporation give all the reps and warranties, because after all, the purchaser is going to buy the corporation. And who's going to back it up if the purchaser now owns the corporation? So in most share purchase transactions, you're going to want the shareholders to back up the reps and warranties. In many cases, the shareholders of a private company or a closely held company will know enough to be able to give the same reps and warranties. But you have to be very careful about dealing with who knows what about a corporation, especially in the share purchase context. And I want to talk a little later about knowledge and the knowledge background and criteria. Also, you want to be sure that in some cases the corporation is a beneficiary of the reps and warranties. For instance, if the existing shareholders have engaged in exciting and aggressive tax planning on behalf of the corporation, and you are buying that corporation, You would like the corporation to be the beneficiary of a rep and warranty that the tax planning has all been within the law, because it will be the corporation that has to pay. Just a thought to worry about. Now, what about knowing? What is it that you want to know? The first thing that you want to know is enough to know what needs to be negotiated further. And one of the purposes of the reps and warranties in a large purchase transaction is simply to highlight those issues that need more thought. That's why you tend to get these sort of kitchen sink agreements coming across, you know, where there are huge sections on environmental liability and pension plans, and you say to the lawyer on the other side, there is no pension plan. This company handles paper and doesn't throw out anything. There are no environmental issues here. Well, you need those kinds of things in there to act as a checklist, because you can be surprised. Sometimes things turn up that you didn't anticipate, and if it's there in the checklist, you'll know enough when the person on the other side says, well, actually, I'm not sure we can say that. Little bells should be going off, because that means that's an area that you need to think more about and to negotiate further. So that's the first thing. In this particular case, for instance, you want to check on environmental matters. This is a manufacturing company, and any manufacturing company has potential environmental liabilities. You also want to check in this particular company about things like the saleability of inventory. Technological inventory goes out of date very quickly. I still have an old IBM PC, the 4.88 megahertz type, that had 2 floppy disks. It still works just fine within the confines of that old machine, but it's generations out of date. It's totally unsaleable now, and computers especially go out very quickly. You need to ask about this particular company where it is in its technology cycle. Is the company redeveloping technology? Is it updating this product? It's selling it as a leading edge product, but is it really leading edge? Have you looked at the rest of the market? You'll need some kind of rep and warranty about that and some sort of investigation in the company about it. So inventory and technology review. The other key asset, the key asset in a business like this is personnel. Now, this is a manufacturing company with manufacturing equipment and inventory and plant, all the traditional things we know about that are valuable, good, hard, concrete stuff. But a technology company doesn't live on its concrete. It lives on its ideas, and those ideas come from people. And if all the people are leaving, you may not have bought as good an asset as you thought. And so you want some reps and warranties in an agreement like this about personnel. Better to send out and ask for too much than forget to ask about something. The second thing that you want to know about is you want to know enough to conduct your due diligence. In the great scheme of things, what tends to happen is we sign the purchase and sale agreement up front and then do the due diligence. Sometimes you can do some due diligence beforehand, but in most cases you won't have access to enough information to do a useful due diligence exercise until after you've signed the purchase and sale agreement. And consequently, the purchase and sale agreement needs to set up the kinds of information about which you're going to conduct due diligence. In this case, for instance, you do all the traditional things. You look at the minute books if you're buying the shares. You're going to do a land review because this company owns land. You're going to look at funding. You're going to look at the licenses that it holds, especially for key information technology assets. This company has licensed all of the information to produce the track buddy, other than the stuff that it developed itself that goes into that memory module. All of that's come in from somebody else. How good is it? How useful is it? How up to date is it? Have you got a wonderful memory module that's hooked onto a unit that's 2 or 3 generations out of date? The other thing that you need to look carefully on and need to get proper reps and warranties about are things like the EDI agreements. Are those agreements up to date? Are they in place? All that shapes your due diligence. And then, of course, from these things, the other thing you have to know about are the closing conditions. The reps and warranties key you into what needs to be done between the time you negotiate the contract and the time you actually transfer the title. What about assignments? What about licenses? What about all the cleanup work that needs to be done in case the corporation can't give the rep and warranty that you want? In this case, for instance, I'll just mention one thing that Fraser might pick up on. In this case, the principals have written software before the company was incorporated. A bell should be going off. They hold the copyright to what they wrote before the corporation existed, and unless they've assigned it in writing to the corporation doesn't own it. And like the Brooklyn Bridge, it's always fun to sell what you don't own, but the purchaser doesn't get much for it. That's a piece of cleanup work that may have to be done. The other key thing you need to know about reps and warranties is information that the vendor has that the purchaser simply can't know about. This is things like, is there pending litigation? That's not something the purchaser can actively go out and find out about very easily, usually. What about the financial statements? Where are the financial statements? Not always a completely accurate picture. And people will fight about these things, I'll guarantee you. Just to tell you a story, because we remember stories better than we remember abstract things. I was once involved in buying a small business, and the vendors of the business said, we haven't made provision for tax liabilities in the current year in our financial statements. The financial statements were based on items that were stuck in a shoebox. This was a company that was run by people who'd run it for many years, and they knew how good a company it was, and you know, accounts come in and accounts go out, and what more do you need than that? And they hadn't made any provision at all for setting aside any money for taxes in the current year. And we knew that. And I thought I had put in the purchase and sale agreement that they were going to be responsible for the taxes. But when it came down to closing the business, they thought we were going to be responsible for the taxes. And I couldn't convince them otherwise, and my client caved in on it. We ended up paying about $45,000 more for the corporation than I thought we should have. Whenever there's an exception, watch out. That was knowledge that should have been reflected in the financial situation, the financial statements, and wasn't. You need to equalize the knowledge in order to get the deal. And if one party knows that something interesting is happening, they better let the other side know. I remember another interesting case where equalizing knowledge was crucial, and this also points to the need for fairly specific but also general reps and warranties. The rep and warranty was that there were no government proceedings that had been brought against this corporation. It was true. There weren't. There had been a 2-year investigation, however, by the Competition Bureau for price fixing. They didn't tell the purchaser that, and the purchaser had to rely on a general rep and warranty that basically said, you've told us everything that if you'd told us, it would have made a difference. And we had to sue under that successfully. But reps and warranties are used to equalize the knowledge that make the deal go. And then finally we get the thing that you all learned in law school, right? That reps and warranties are there to deal with a right of action. And that's true enough, but who wants to buy a lawsuit? That's the last resort. That's only the thing that you wheel out when there's nothing left. What they're really there for is equalizing the knowledge and setting up, the other side of equalizing knowledge is setting up the risk allocation in the agreement. In an agreement of purchase and sale, there's some risks that the purchaser is going to bear. How do you know when the purchaser is going to bear a risk? Because the vendor won't give an unqualified rep and warranty. What kind of qualifications? Well, the obvious ones, materiality. In all material respects, we're in compliance with X, Y, and Z. And in what respects are you not in compliance? Because those are risks that the purchaser is bearing. And what does materiality mean? It's something that you need to think about and negotiate. How material is material? Is there a dollar figure on material? Or are there key assets where you can't, as a purchaser, live with a materiality exception? Second one, trotted out all the time, to the best of the knowledge, such and such is true. Very good. How much investigation and how much knowledge does that person have? Do they really know what's going on? Did they know that they used to plow oil into the back 30, 40 years ago? And that you've got a huge environmental liability on your hands? That was the accepted practice at one point, by the way, for disposing of oil waste. Just plow it in the ground, it'll go away, it'll break down. And it does, it flows right down to the groundwater. The corporation has to act through agents. But let's make sure that the people who are giving the reps and warranties actually know something and are not going to hide behind the fact of, oh, I didn't know that. Well, you should have known it. Well, I didn't, and you didn't ask me to do any investigation. And then finally, of course, the exceptions that are obvious, the exceptions. I can't give you that rep and warranty. We'll have to make an exception for it. It's not true. There's a risk the purchaser's bearing. In a lot of cases, the purchaser's willing to bear that risk. That's okay. There are a number of specific types of reps and warranties. I've set them out in the materials. I don't think I'll spend time now going through them because I don't want to take time away from the more specific things. Things like authorization, capacity to perform, and I've broken them up that way. Authorization, capacity, making sure that you get value for what you're paying for, the complete information problem, the risk allocation, and then a number that are specific to the IP area. They're also in that particular section at the end of the notes. They are ones that cause some particular concern. Let me just make a few comments about drafting IP reps and warranties, and then I'll hand it over to Fraser, and then if we have questions, we'll have time for that. When you're defining intellectual property assets, you have to decide whether you're going to define intellectual property generically and then talk about the corporation's IP or the vendor's IP or whatever it is, or whether you're going to define it specifically. That's just a drafting issue, but don't get confused and fall between both stools. Do some of it some way and some of it the other. I've seen a lot of that. Some intellectual property is owned by the vendor, but a lot of intellectual property is actually acquired by license. That means that the vendor can give a rep and warranty that it has all the rights in its own intellectual property, and it has all the rights in the licensed intellectual property that it needs to conduct the business. And those are indeed reps and warranties that you want on a regular basis. But you probably can't give the rep and warranty that the vendor has all right, title, and interest, all of which means the same thing, in the intellectual property, because that won't be true. Other people will have rights, titles, and interests in it because it's just been licensed. So that's just a clarification when you're drafting these things. If you have intellectual property that's been licensed to the corporation, think about how you're going to give the rep and warranty on ownership. Lists of intellectual property are something we often ask for. They can be beastly hard to obtain. Every time someone sets pen to paper, there's copyright in what's been written. Are you going to list every piece of paper in the corporation? The following is a true and complete list of all intellectual property. Is it really? It's much easier to get complete lists of all registrations. It's certainly possible to get complete lists of all patents and patent applications because those are specific, discrete items. But with copyright, with trade secrets, with know-how and other kinds of confidential information, much harder to get a list. Think about what you really need there and what you can get away without. There are also specific differences in the reps and warranties that are required that the property is in good standing. A corporation ought to be able to give an unqualified representation and warranty that its own intellectual property is in good standing. It's much harder to give an unqualified rep and warranty that property that it has licensed is in good standing because that's not under the control of the licensee. All of that you can normally get is that that the vendor hasn't done anything to compromise the value of the intellectual property that's been licensed. Also, just a practical point and a rep and warranty that should come up in relation to software. If you are buying a key piece of software, and if that piece of software is not something like a mass market product, you will want to try to ensure that that software can be maintained. Maintaining software is one great headache. First of all, you may not have a programmer who speaks the arcane language in which it's been written. How many of you know how to program in Snowball? Yes, there is such a language. Or APL means a programming language. These are real languages. Software was really and truly written in them. But it may be very difficult to find anyone now who can speak them. This is part of the whole Y2K problem. Everyone had to go back and find COBOL programmers because of all the COBOL programs that were written back in the dark ages. But it's not just a question of programming skill, it's also access to the code. Do you have access to it so you can change it? Do you have the right to change it? And has it been properly documented so you have the faintest idea what all this stuff is doing there? I don't know how many of you have ever looked at a computer program to figure it out. It's very difficult to figure out somebody else's program, I can tell you. And so as a practical matter, when you get reps and warranties for software, get some assurance that this stuff can be maintained. Just a point. And with that, I'll segue over to you, and then we can take any questions between us.
It's a good segue, Hugh. I think I must be a brave man to stand between you and the coffee twice in the same day. What I'm just going to touch on following Hugh is some of the specific representations and warranties that you want to cover in terms of the intellectual property. Some of these are specifically in relation to the intellectual property, but what you find is that many of the general representations and warranties in a purchase agreement are broad enough, whether we're talking about compliance with law or compliance with contracts and so on, are broad enough that they extend to the intellectual property, and you want to make sure that you understand how they apply in relation to the particular business of the company. Now, with respect to intellectual property owned by the company, and Hugh mentioned the problem of listing all intellectual property, I certainly agree with that. But let's assume that you do have a list at least of some of the major intellectual property, and you want to deal with software, for example. Hugh mentioned the problem of whether there's a written assignment agreement from the majority shareholder in this case, who is not an employee, from the consultants who are not employees. We touched on that this morning. You also want to address what rights have been granted in the intellectual property that purportedly or supposedly is owned by the company to third parties. And particularly if we look at the way in which software was distributed before the internet came along, it was very common to have resellers, to have distributors, or to have licensing agents, particularly where the software was being distributed in other countries. So you want to make sure that the reps and warranties are broad enough that you cover any rights that have been granted to third parties in the software or other intellectual property that, as I say, supposedly belongs to the company. Now, with respect to licensed software that originates from third parties, it's very easy to overlook this, and it's easy to overlook it from the point of view of a technical due diligence or in terms of the contracts that may be in place. And one reason for this is that, for example, when a product such as TrackBuddy is being developed, and as Hugh cleverly indicated in the fact situation, that does include some third-party components, but quite frankly, the principals of the company quite often forget that there are third-party components in there. And so they may either not realize that there are some runtime software products, for example, that are part of the company's products. They may not realize that a developer of a website has incorporated some of its software as part of the contents of the website and has reserved certain rights in the agreements between the developer and the company. So you need to really review that very carefully, find out as part of the technical due diligence what software is there from third parties, and then you need to address the issues that we talked about this morning, that there has been compliance with all of the applicable restrictions in the license agreements from the third parties in terms of any distribution of the software, any sub-licenses granted to the software. You need to deal, of course, as soon as you talk about either an assignment of rights to third-party software or a sale of the business by way of a sale of shares involving a change of control, then you need to deal with the consents, and the reps and warranties should cover whether consents have been obtained, whether transfer fees are payable to the licensors, and whether they have been paid. Now, in terms of the conduct of the business of CyberStore, and again, looking really at the more general reps and warranties, you're going to have some representation and warranty that the business has been conducted in compliance with applicable law. And you need to address questions of where the business is being conducted, where is the company actually selling its products, where are agreements made with end users. You need to consider, for example, where the buyers are located for purposes of consumer protection legislation. There is some legislation in some jurisdictions, I think California is one, where they address specifically the issue of who is bound by consumer protection legislation for purposes of electronic sales of products. So, and there may be special legislation, for example, in jurisdictions such as Australia, dealing with business practices with which you may have to comply if, in fact, you are selling into those jurisdictions by means of the internet. Rob raised this morning the issue of export legislation, export controls on certain types of technology, such as encryption technology, maybe controls on the import of that technology. And again, you need to consider that in terms of a general representation as to compliance with applicable law. I mentioned this morning the problem of the use of the devices that are marketed by Cyberstore for downloading music from the internet, whether or not Cyberstore itself may be involved in that activity. And you need to recognize that the Copyright Act not just gives a cause of action to the copyright holder, but also provides for what are, in effect, criminal remedies. There are new provisions in the Copyright Act dealing with statutory damages, and again, that may be part of the exposure that you need to address. And all of that may come, again, from that very general representation and warranty, and you need to need to consider whether that's broad enough. As far as registrations are concerned, you want to find out what the status of any registrations, whether it's for purposes of patents or trademarks or domain names, whether there are applications that have been filed, whether they are being properly prosecuted, have not been abandoned, whether all necessary registration and filing fees have been paid. You need to consider, again, what jurisdictions the company is carrying on business or using trademarks or using domain names, and whether really all the registrations are required in order to protect the rights of the company in its trademark or domain names. And again, this is part of a process that you have to go through with the purchaser, consider how important the particular IP registration may be. Perhaps in this case, the cyberstore.com domain name registration is the most valuable part of the business. It really depends on the purchaser and what the purchaser expects to get from the purchase of the business. So consider really the economic importance, and then how broad the representation and warranty should be, and how that should be tied into the searches that you as the purchaser will want to conduct as part of the due diligence. As far as the warranty concerning infringement of intellectual property rights, you really want to cover this from two perspectives. You want to know that the use of by the company of its intellectual property, the conduct of its business does not infringe the rights of any third party. You want to know, at least to the extent you can find out, that no claim has been made by any third party against the company as well in terms of infringement of the rights of a third party. So you need to know, of course, that there's no litigation, there are no claims outstanding, there are no disputes outstanding concerning domain names. And again, this needs to be tied into the registries in which the domain names have been registered or could be registered, as well as the jurisdictions in which the trademarks have been or could be registered. Just want to touch on non-disclosure. And for a company such as Cyberstore, obviously its technology and intellectual property are the most valuable asset. And what you want to cover in the reps and warranties is the extent to which there has been disclosure of the key proprietary know-how outside the company, the extent to which consultants have been exposed to the technology, whether or not there have been non-disclosure agreements made with any third parties, whether the key proprietary know-how, the source code, for example, has been disclosed at all outside the company. And you need to know that if there has been any disclosure, that there are proper non-disclosure agreements and that these are binding and that they accrue to the benefit of the purchaser. Hugh touched on the technology, whether the technology works, whether it does what the vendor says it does. And I just want to touch on that point. I think you certainly want to consider having some representation and warranty that the software, the other technology conforms with any specifications that may be available, with any technical documentation. You need to have your technical people review all of that. One of the problems here is that the documentation itself may be incomplete, it may be inadequate, it may be out of date. So if you really want to put the cat among the pigeons, what I would ask for is a representation and warranty that the technology and intellectual property does what the marketing literature says it does. And then you'll find out whether or not it's technology that your client wants to buy. As I say, I just want to touch on a few points, and I think we have some time for questions now.
Anybody have any questions, either for John or
We've either totally stupefied you or answered every question there is. Yes. Yeah, that's about it. It's one of those things that you may actually want as a closing condition that certain individuals sign employment agreements with the new employer, if there is a new employer. Beyond that, I don't know, practically there isn't much you can do. People are very mobile.
I think that's right, but you certainly touched on, I think, one of the real risks when you buy a business in the high-tech sector. And that is that because of a change in management, the employees who are there, for whatever reason, may leave. And so I think you need to address that very carefully in terms of whether you can, in fact, get employment contracts with the key personnel and whether there are these non-disclosure agreements. And look at it in the context of who is key to the company in terms of the technology in particular. And even with non-disclosure agreements, of course, you can't prevent them from using what is in their heads, and they may very well go out and start a new company. That certainly has happened.
Yeah. Other? Yeah.
I have a question you mentioned as a drafting issue. When you're defining the IP assets,
Mm-hmm.
you say do it either generically or specifically.
Mm-hmm. Well, you may have to do both within the same agreement. And what you would do is you define intellectual property in a generic sense. So intellectual property means all copyrights, patents, and trade secrets. Corporation intellectual property means all of the intellectual property in which the corporation has rights. You'd probably do both of those. But I've seen agreements where intellectual property is used sometime to mean generic intellectual property, and sometimes it's used to mean the intellectual property owned by a corporation or the vendor or somebody. And that's the confusion you should avoid. Does that resolve that one?
This is, this is getting the licensor of software that has been licensed to the company? Right.
Mm-hmm. We don't typically.
Not typically, no. I mean, it may be something that you would address as part of due diligence and maybe have the vendor get confirmation from the licensor that fact. I don't think it's standard.
it's an interesting point because, of course, we do routinely do that with landlords, right? We get estoppel certificates from a landlord, and why shouldn't we get an estoppel certificate from a major software supplier like a system, the operating system supplier? But it hasn't been the practice. But there's no reason why you couldn't. It wasn't. Yeah, that.
And then you got a problem because you don't really care about damages.
You want the software.
Absolutely, yeah.
Yep.
And again, I think this is a part of the analysis of how important any particular IP is for the business. And if this is key to the business, I agree with you. There's no reason why you shouldn't ask for it.
Yeah. Oh, way.
Big issue always is survival of reps.
Mm-hmm.
On the IPIT, I feel what's appropriate, not appropriate, what asset should be.
I don't know why I'd think it would be any different from any other asset. You have some particular problems with patents that expire. If the patent's about to expire, obviously the rep and warranty that the patent's in good standing won't live any longer than the patent itself does. Other than that, why would you make a distinction? It's an asset. I don't think so.
Well, the Copyright Act has a provision that an action must be brought within 3 years, but I don't know if that really would affect the length of the survival period.
Of a survival period.
Well, if they only have 3 years, we wouldn't care to negotiate for a 5.
For a 5, that's true. The other problem you run into with copyright that's been out there for a long time is the 21-year reversion rule.
That's right. Yeah, after a certain period of time.
After a certain period of time, after the death of the author, the copyright will revert back to the estate. But that's not usually such a problem with software. I mean, this is a problem if you're dealing in the entertainment industry with music or literary copyright. But no, Stan, it's a good question. I just don't think there's a particular worry. Other things? There you go.
For anyone who ever listens to the recorded version of this, I just realized that they will have the answers to the questions, but they won't have the questions. So if anyone's listening to this on tape, sorry, but I just forgot about it.